This is a memorandum of law concerning the U.S. Supreme Court's abuse of the 10th Amendment. This is a series of memorandums of law, video number 2, by NationalLibertyAlliance.org. The federal judiciary has stolen our 10th Amendment. The 10th Amendment reads, "The powers not delegated to the United States by the Constitution, nor forbidden by it to the states, are reserved to the states, respectively, or to the people." America's narrative is anything but the laws of nature's God. Liberty, once lost, is lost forever. John Adams. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights government are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter it, and to institute new government servants, laying its foundations on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Declaration of Independence. If a nation expects to be ignorant and free in a state of civilization, it expects what never was and never will be. An enlightened citizenry is indispensable for the proper functioning of a republic. Self-government is not possible unless the citizens are educated sufficiently to enable them to exercise oversight. It is therefore imperative that the nation see to it that a suitable education be provided for all its citizens. Educate and inform the whole mass of the people. They are the only sure reliance for the preservation of our liberty. Thomas Jefferson. James chapter 1, verse 25. But whosoever looketh into the perfect law of liberty, and continueth therein, he being not a forgetful hearer, but a doer of the work, this man shall be blessed in his deeds. NationalLibertyAlliance.org. The purpose of this memorandum is to clarify the judicial powers of the federal courts from the powers not delegated to them. A key issue in point that was a direct assault on the 10th Amendment, where the people are to decide through courts of justice, is abortion, which is a natural law issue and not a legislated law issue that was unconstitutionally adjudicated by the United States Supreme Court, which is an equity court governed by codes and statutes, which then brings the issue into its proper jurisdiction, a natural law court of record, adjudicated by the King's Bench, which is a jury of we the people, made up of 12 people who are to mirror the will of nature's God, answering to him alone. The United States Supreme Court does not have the authority to think like God's adversary, that they can change God's laws. Daniel chapter 7, verse 25. And he shall speak great words against the Most High, and shall wear out the saints of the Most High, and think to change the times and the laws. In a letter to William Jarvis, Thomas Jefferson wrote, "The assumption of sovereign power and the institution of government by consent are acts of transcendent authority, which the people alone are competent to perform. And accordingly, it is in the name and by the authority of the people that the judiciary was vested. In another letter to Judge Spencer Rowan, he wrote, "You seem to consider the judges as the ultimate arbiters of all constitutional questions, a very dangerous doctrine indeed, and one which will place us under the despotism of an oligarchy. Our judges are as honest as other men, and not more so, and their power the more dangerous, as they are in office for life, and not responsible, as the other functionaries are, to the elective control. The Constitution has erected no such single tribunal, knowing that to whatever hands confided with corruption of time and party, its members would become despots. The Constitution is a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they please." In another letter to Thomas Ritchie, he wrote, "The judiciary of the United States is the subtle army of military engineers and miners, constantly working underground to undermine the foundation of our Confederate fabric. They are construing our Constitution from a coordination of a general and special government to a general and supreme one alone. This will lay all things at their feet, and they are too well vested in English law to forget the maxim, 'Good judges have ample jurisdiction.' A judiciary independent of a king or executive alone is a good thing, but independence of the will of the nation is an error, at least in a republican government. The original error was in establishing a judiciary independent of the nation, and which from the strongholds of the law can turn its guns on those that they were meant to defend and control, and fashion their proceedings to its own will." The federal judges have destroyed our courts of justice, and this could have been prevented if it were not for the people being lulled to sleep through political parties as we unwittingly yielded judicial control into the hands of the treacherous bar. And over time we lost our most important anchor of government by consent, a free and independent jury that has the power to have prevented the unlawful advances of the judiciary despots. It is up to the people to remind our servants of who they are and the consequences of their behavior, should they not retreat back under the chains of the Constitution. We, the people, vested Congress with the authority to write the law within the criteria of Article 1. We, the people, vested the United States Supreme Court in Article 3 to protect the unalienable rights of the people and to act as an appellate court to inferior federal district courts. We, the people, vested Congress in Article 1 with the authority to constitute tribunals inferior to the Supreme Court. We, the people, vested these inferior courts with jurisdictions over Congress's presently established 57 U.S.C. titles legislated under Article 1, Section 8, and to champion the unalienable rights of the people. We did not vest federal courts with the authority to decide people's behavior, political issues, or criminal cases, or civil cases without our permission. We vested the federal judges in equity cases only. The following is the short list of 10th Amendment tyrannical federal judiciary violations and the seizing of jurisdictions never vested to them, and the interfering with of numerous issues that clearly belong to the states respectively and the people. Some of them are court rulings to stop the people's referendum, English as their official language. Court rulings to stop the people's referendum to stop state-funded taxpayer services to illegal aliens. Court rulings to stop the people's referendum not to give special rights to homosexuals. Court rulings to stop the people's referendum to defeat a tax increase. Court ruling to stop the people's referendum to limit contributions to state candidates. Court ruling to stop the people's referendum against physician-assisted suicide. Court ruling to stop the people's referendum to define a marriage as between a man and a woman. Court ruling to stop state legislators for term limits for politicians. And a court ruling to stop state legislators for marriage amendments. And a court ruling to stop state legislation for marriage laws. Federal district courts betrayed the people by denying the very rights they took an oath to uphold, protect, and defend. Court's denial of Amendment 1, the unalienable right to petition the government for redress of grievances. Court's denial of Amendment 2, the unalienable right of the people to keep and bear arms. Court's denial of Amendment 4, the unalienable right of the people to be secured in their persons, houses, papers, and effects against unreasonable searches and seizures. Court's denial of Amendment 5, the unalienable right to a natural law grand jury not to be put in double jeopardy and not to be a witness against oneself. Court's denial of Amendment 6, of an unalienable right to an impartial jury and a non-bar assistance of counsel. Court's denial of Amendment 7, the unalienable right of a common law jury and a natural law jurisdiction. And Court's denial of Amendment 10, the state and the people's right of powers not delegated to the United States by the Constitution. Politically motivated federal court judges seize control of political issues, stealing state jurisdictions, interfering with executive duties, serving foreign interests, and advancing progressivism, liberty's greatest enemy. Court legalizing murder via abortion that natural law will not permit. Court interfering with the President's constitutional duties to protect our borders that the executive powers will not permit. Court claiming jurisdictions covertly under maritime jurisdictions for criminal cases under U.S.C. Title 18 that natural law will not permit. Court adjudicating prescriptions law within the states that the 10th Amendment will not permit. Courts adjudicating marijuana laws within the states that the 10th Amendment will not permit. Courts forcing same-sex marriage rights upon the states that the 10th Amendment will not permit. Courts creating and harboring tax courts that Article 1, Section 8 and 9 will not permit. Court concealing the people's unalienable right of natural law courts via the rules of the court. And courts marginalized the science of government by consent by seizing control of the grand and petit juries through covert means. Clearly, the aforesaid violations are an attack upon our republic, whereas the judiciary is using our courts to advance progressivism, whose endgame is socialism. Thomas Jefferson said, at the establishment of our Constitution, the judiciary bodies were supposed to be the most helpless and harmless members of the government. Experience, however, soon showed in what way they were to become the most dangerous. A judiciary independent of a king or executive alone is a good thing, but independence of the will of the nation is a mistake, at least in a republican government. The seat of dissolution of our federal government is in the Constitution of the federal judiciary. An irresponsible body, for impeachment is scarcely a scarecrow, working like gravity by night and by day, gaining a little today and a little tomorrow, and advancing its noiseless steps like a thief over the field of a jurisdiction until all shall be usurped. The candid citizen must confess that if the policies of the government under vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the instant they are made, in ordinary litigation between parties, in personal actions, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal. Article 3, Section 1 states that judges, both of the Supreme and inferior courts, shall hold their offices during good behavior. And if the Congress cannot find the backbone to impeach judges for bad behavior, then we the people will, via indictments. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda versus Arizona. The Rules Enabling Act of 1934, passed by Congress in 1934, gave the Supreme Court the power to make rules of procedure and evidence for federal courts in equity, as long as they do not abridge, enlarge, or modify any substantive right. Rules are not law. They are just rules with no authority to group together suits in equity and suits at common law under the term civil law, also known as Babylonian law. Congress doesn't even possess such authority. We the people, via the Constitution, ordained only law and equity under Article 3, Section 1, Section 2. The Supreme Court enacted uniform rules of procedure for the federal courts. Under the new rules, suits in equity and suits of common law were grouped together under the term civil action, claiming that rigid application of common law rules brought about injustice. This was an act of treason, whereas the United States Supreme Court and the U.S. Congress, under the teaching and guidance of the treacherous, subversive American Bar Association and the aforesaid anti-constitutional associations, in an act of treason, executed a silent coup by claiming the abrogation of the common law, also known as natural law, with its unalienable rights that were endowed by our Creator, and covertly substituted them with civil rights legislated by lawless men. Equity cases. All equity cases under the acts of Congress are tried in federal district courts. The United States Supreme Court is an appellate court and is the final arbiter and interpreter of all legislative law cases appealed out of the federal district courts. They are also the final arbiter in the constitutionality of all codes and statutes and acts of Congress when challenged. Law cases. The United States Supreme Court, being the highest court in the land, is final arbiter of all cases concerning any rights violation arising out of any of the courts of the land. Therefore, when a case is moved into federal district court for a rights violation cause, the said federal district court is expected to champion the unalienable rights of the people. If the district court fails to secure the rights of the people, the case can be appealed, and the United States Supreme Court is the final arbiter. If they fail to protect the rights of the people, they are in bad behavior and can be impeached. Case in point. Any village, city, town, county, state, or federal court that violates the people's right of due process, and when such a violation is brought before the federal district courts, it is expected to order the lower courts to cease and desist if they are incapable of providing due process or when they lack jurisdiction. As far as the issues of the case are concerned, the federal district court and the United States Supreme Court has no jurisdiction to hear the case. If the inferior court can survive the challenge, the case must be moved to a trial court of law for adjudicating on the facts. The judiciary is in bad behavior and is to immediately cease their lawless jurisdictional advances to spread their socialist agendas or suffer the consequences of indictments for subversion, conspiracy, of treason.